12 months after Article 370 was abrogated and internet services shut down in Jammu and Kashmir, the Supreme Court ruled on a bunch of petitions against the restrictions. While the top court was clear the use of internet is part of a citizen's fundamental right, it stopped short of directing the central government to lift the internet ban. Instead, the Supreme Court has ordered that the government immediately review its suspension orders in light of the observations the court has made. They have to produce all the Section 144 orders that they have issued and use those parameters before suspending internet services in the future. Restoration of internet for essential services such as government and banking related websites, hospitals, etc. has also been ordered. Now, while the statements made by the Apex Court in its judgment are heartening as far as freedom of expression and the internet goes, has the ruling offered real and immediate relief to the people of Jammu and Kashmir? To speak more on this, I'm joined this evening by Tehseen Poonawala, a Supreme Court lawyer and one of the petitioners in the case. I'm also speaking with Vikas Singh, President of the Supreme Court Bar Association and former Additional Solicitor General of India. Welcome to both of you and thank you for speaking with us today. Tehseen, let me start by asking you what you make of what the Supreme Court has said. Your petition was one of those that was answered today. Has it provided real relief?
First of all, I'm extremely grateful to the Honorable Supreme Court for the judgment that the Honorable Supreme Court delivered today with regards to the shutdown of the internet in Kashmir as well as Section 144. Tamanna, there are a couple of things that we need to understand. When I moved the highest court of our land on 12th August after 370 was abrogated but there was a shutdown, I had two basic points to make. That once 370 has been abrogated, the Indian Constitution applies to the state of Jammu and Kashmir, now Union Territory. In which case Article 21 cannot be suspended, neither can Article 19 and 14. This is the basic structure of our Constitution. This is the doctrine of our Constitution, the basic structure of our Constitution. The second thing that I was talking about was when 144 is imposed, all of these magistrate orders need to be produced before some judicial authority that this can be challenged. The learned SG said that most of these orders were not legally competent. He used these words in the Honorable Supreme Court that they were not legally competent, and I found that astounding. As so far as the internet is concerned, I linked it with Article 21, the right to life and liberty, and Article 19. Now you see, most of our insurance, including Ayushman Bharat, is linked to the internet. Your medical records are on the internet. Most of your business happens on the internet. You require OTP, you require to generate business. Modi ji said it must be a digital India. How can internet be suspended indefinitely? Right. If there is a threat of terror, you shut down certain microblogging sites, etc.
Tehseen, I know the arguments. Tehseen, I know the arguments. I'm asking you that do you think enough relief has been granted? The government has to review all of its orders currently. It has to provide the basis of its orders. But there has been no revocation of the suspension of internet as of now.
In the days and times that we are living in, for me, just holding your ground and accepting that internet and right to freedom of speech is a fundamental right, is a big thing. Because day after day we are losing our liberty. To hold on to a position is like a victory in itself. Yes, now there will be the reviews. All 144s will have to be reviewed, the internet will have to be reviewed, and I will further challenge this. Not only will I challenge this, I will also challenge the Uttar Pradesh arbitrary 144 applied in the entire state, because those orders were not produced. The DGP had applied it, not a district magistrate. Even that will be challenged on the basis of this order. It's a long battle, it's a tough battle, but one step at a time is what I believe in. And at times we're living in where we're going backwards, holding ground or moving one step forward is a victory, definitely a victory.
Vikas Singh's view. Sir, how do you look at some of the observations that the top court has made today, and I think crucial among them, which will have far-reaching impact, and tell me if my assessment is correct, I would like to hear your view, is that access to the internet has been recognized as a fundamental right, which would have far-reaching implications, as I understand, even beyond the situation in Jammu and Kashmir.
Well, if you ask me, Tamanna, the judgment, according to me, has been a bit of a disappointment. Because if you look at the stand taken by the government right from the beginning, or the stand taken by the petitioners also right from the beginning, is that the government has not specified what law they have used to ban the internet or the telecom services. Now, there is a rule which permits the government to ban these services, which is the temporary suspension rule of 2017. And you will be surprised that this rule was not even referred to by the government in its argument. So, the only way this suspension could have happened was by invoking those rules. And since they had not invoked those rules, so the initial order itself suspending was completely without jurisdiction. Now, we have to appreciate that we are in a country which is governed by the rule of law. And if there is a law, and if the law says that a particular thing has to be done in a particular manner, then it has to be done in that manner alone or not at all. If the government had no defense to say that there is any rule invoked or any act invoked for this suspension, then according to me, the Supreme Court should have 4 or 5 months back passed an interim order restoring this suspension rather than waiting for 5 months to pass this judgment. Now, the other disappointment is that even today, when the judgment has been passed, the justification, if there is no justification to violate somebody's fundamental right, and when you've held that it is a fundamental right, then why not say from today itself, overnight, today, immediately, with the next minute, that internet services will have to be restored in the entire state of Jammu and Kashmir or the Union territories of Jammu and Kashmir. So, according to me, this judgment has been quite a disappointment. It may have said high-sounding words of fundamental right, etc. But if the benefit of the guarantee is not given to the people, and if it is again left to the subjective satisfaction of the government to decide to recall, give them time to recall. Now, tomorrow, if they want to pass an order under the rule, then the whole thing will again get mired in the same kind of problem of people not getting the benefit of this judgment. So, according to me, it may have said a lot of things, but it has given no relief to the common man. And that is quite a disappointment, because this judgment should have given this relief immediately the day the judgment was passed, if not having done an interim order earlier, which should have come a couple of months or 4 months back. So that is my view on this judgment.
So how do you see it, Tehseen? How do you see this panning out? Now, the fact that the government has to explain why it has, passed certain orders, do you think that will give some relief and succor going forward? Because at the end of the day, you will have to prove the relevance under law. Also, the bigger message going forward, you talked about, that you're planning to pursue legally Section 144 imposed in Uttar Pradesh. This judgment is also important because it tackles the very basic debate, which is your liberty versus your security, and how governments apply the law. Do you think it sets some very crucial framework on this, or is there enough room for interpretation for any government as they so wish?
No, I mean, the government will always try and interpret a judgment to suit its narrative. And ours, people like Vikas sir or me, our duty is to keep challenging it in court and uphold the basic principle, the basic principles of our constitution, the spirit of our constitution. There are two important aspects that this judgment dwells into. You see, until now, what would happen is the government, under the vague national security subject or public security, public safety, would brush everything underneath the carpet. This judgment explicitly says that nothing can be indefinite. Everything has to be reviewed, has to be put in public domain, and people must challenge everything, including 144 and the internet ban. That authority is an absolute fundamental right. It was obviously given before, but now the judgment makes it clear, which means that people can now start questioning and challenging things that the government does under the garb of national security or security for you and me. We must understand that, of course, security is very, very important, but security cannot be at the cost of liberty. I don't want to get political here. I want to stick absolutely to legal arguments. But if I were to think politically, why in 2016 did we do demonetization and destroy our economy? We were told it was for national security, for terrorism. So who's responsible for that? Yeah. So somebody in a democracy, you got to be answerable at some point. You can't put everything underneath the carpet and say everything is a national security.
One of the important points I want to point out, because I was going through the judgment, is where the judgment says none of the councils have argued for declaring the right to access the internet as a fundamental right, and therefore we are not expressing any view on the same. Do you think that was a lapse? That was a lapse because
no.
it was not clearly addressed as an issue of fundamental right of using the internet, and that seems to be at the core of it.
So, in my written submissions, I can say this for a fact. Meenakshi Arora was arguing for me in our written submissions. We very well quoted the Kerala High Court judgment that said that the right to internet is a right as a fundamental right under Article 19. We quoted that extremely well, but we linked it to right to life and liberty in Article 21 and right to Article 19. Now this judgment is slightly nuanced. It says, well, through the internet, the right to do your business, the right to express your opinions, the right to even dissent, the right to do everything is a fundamental right, and that can't be taken away. If that can't be taken away, then obviously if I'm doing it through the internet is a fundamental right of mine. How can the internet be taken away? Number two, it says internet cannot be taken away indefinitely. It's very important. So that must be restored to people, or that must be put out in public domain, while it's being taken away for a short period of time. So the judgment is slightly complex, but that argument was made in written submissions, at least in my written submissions. That was made.
I want to include in this conversation now Mr. Basharat Andrabi, a resident of Srinagar, because very often we talk about Kashmir with, actually not enough participation of Kashmiri voices in the conversation. Mr. Andrabi is on the phone line with us from Srinagar. Mr. Andrabi, welcome to the show. I just want to get your thoughts on how it has been living without the internet for the last 5 months, how it has impacted you.
Good evening. Good evening. Hello.
Yes, Mr. Andrabi, can you hear me?
Good evening to all the viewers of your channel.
Yes, sir.
Hello.
Yes.
Hello. I would like to speak in Hindi.
कोई बात नहीं, आप बात कीजिए हिंदी में, कोई बात नहीं अंद्राबी साहब.
So that all your viewers will come to know how.
नहीं, हमारे व्यूअर हिंदी भी समझेंगे, कोई दिक्कत नहीं, हमारे व्यूअर हिंदी भी समझेंगे. आप ये बताएं कि 5 महीने से ज्यादा हो गए कि इंटरनेट है नहीं कश्मीर में. आज सुप्रीम कोर्ट ने इस पर अपना जजमेंट बताया है, लेकिन बिना इंटरनेट के क्या दिक्कतें आ रही हैं?
मैडम, ये जो इंटरनेट पे पाबंदी जो हमारे यहाँ लगी है पिछले पाँच महीने से, 4 अगस्त से टिल डेट, you can ask this pain to the people of Assam, people of UP. Hello.
Yes.
पीपल ऑफ यूपी, जिनसे 4 घंटे या 3 घंटे या 2 दिन के लिए छीन ली गई थी, तो फिर उन्होंने क्या फील किया है? इट इज हमारी प्रॉब्लम यही नहीं, इंटरनेट ये नहीं है, हमारे जो प्रीपेड फोन कनेक्शन है, देयर सर्विसेज हैव बीन स्नैच्ड. Thousands of phone lines are thousands of people are without phone connectivity. हमारी सबसे बड़ी बात तो हमारी लिबर्टी को पे अटैक किया गया. हमारी लिबर्टी पे अटैक किया गया.
नहीं अंद्राबी साहब, हमें ये समझाया, क्योंकि आज जो सुप्रीम कोर्ट ने बताया है कि इंटरनेट होना एक फंडामेंटल राइट है, और इसमें बिजनेस के लिए किसी भी जरूरी काम के लिए ये, तो आपकी जिंदगी में आपके आसपास बिना इंटरनेट की क्या दिक्कतें आ रही हैं?
सारा यहाँ का टूरिज्म ठप है, यहाँ की बैंकिंग ठप है, यहाँ मतलब जीएसटी जो हमने भरना होता है उसके लिए हमारी प्रॉब्लम है. वी आर फेसिंग सो मेनी लॉट ऑफ प्रॉब्लम्स. अगर हमारी तो सबसे बड़ी बात यह है कि काश हमारे पास जो ये मेंबर ऑफ पार्लियामेंट थे जिन्होंने मेज बजा के आर्टिकल 370 को अबॉर्गेट करने के लिए तालियां बजाई थी, मेज बजाए थे, काश के वो इन 5 महीने में यहाँ आके हमारे दुख दर्द को समझते कि हमारे साथ क्या हुआ.
आप बिजनेस चलाते हैं, आप श्रीनगर में बिजनेस चलाते हैं, आपको किस तरह की प्रॉब्लम्स आई हैं?
मैडम, ये आप यहाँ आके हमारे पास आए और फिर देखें, लोगों से मिलें और उनको बताएं कि आपकी तकलीफें क्या क्या है. हॉस्पिटल्स में तकलीफ है, स्टूडेंट्स को तकलीफ है, व्यापारियों को तकलीफ है, हर एक आदमी इसकी वजह से मुसीबतें झेल रहा है. क्योंकि एक तरफ तो डिजिटल इंडिया है, दूसरी तरफ हम अभी स्टोन एज में जा रहे हैं.
इसके कुछ एग्जांपल्स बताइए अंद्राबी साहब, आपके डे टू डे जिंदगी में किस तरह की दिक्कतें आई हैं स्टूडेंट्स को, आम लोगों को, और अब जब सुप्रीम कोर्ट कह रही है कि आपका फंडामेंटल राइट है, इससे आपको दिलासा मिल रही है?
डेफिनेटली, अगर हम तो वेलकम करते हैं सुप्रीम कोर्ट के इस डिसीजन को, मगर प्रॉब्लम यह है कि क्या हमें राहत मिलती है कि नहीं मिलती है, क्योंकि हमारे हर चीज पे हमारे ये होता है कि ये चीज सिक्योरिटी के अंडर है, हर चीज हमारी सिक्योरिटी की तलवार हमारे पे लटकती रहती है कि भाई ये अंडर सिक्योरिटी है, ये ऐसा होगा तो वैसा होगा। तो मेरा कहने का सिर्फ इतना मतलब है, मैं उन लोगों से कहना चाहता हूं जिन्होंने 5 अगस्त को पार्लियामेंट में टेबल बजा के इस चीज का स्वागत किया, काश वो लोग आके हमारी इस मुसीबत को, हमारी इस जो हमने ये झेला हुआ है इंटरनेट के बंद होने से, और जो हमारे टेलीफोन लाइनें बंद हैं, जो हमारे प्रीपेड फोन बंद हैं, काश वो आके ये देखे कि हमारे साथ क्या हुआ।
बिल्कुल, बहुत बहुत शुक्रिया अंद्राबी साहब हमसे बात करने के लिए। बशारत अंद्राबी is a businessman in Srinagar, and we wanted to get a sense of how it is, living without the internet. Mr. Vikas Singh, I want to bring back the focus on this, because in the spate of protests that took place recently, and India, is unfortunately very close to the top of the list of countries which regularly suspends internet connections. Now, even the court talks about the needs of a government which wants to maintain law and order to use this as a tool. Does this judgment give any kind of a roadmap on how this can be judiciously used so that internet is not shut down to stop dissent, but can be used only to protect law and order and security?
Well, according to me, this judgment, of course, has held some good things about internet being a fundamental right, etc. But if you ask me, the way commerce has grown in this country or even worldwide, including this country, now telecom facility, and which now internet is a very integral part of telecom facility now, is a very, very important medium for doing commerce. Now most of us, when we book tickets or we book hotels, we all use various websites and we go straight to the website and do our booking. Similarly, businessmen have also started using the facility for the purpose of doing their commerce and their business, and most of them, or rather a very major part of the business activity now is dependent on internet. So now with this ban being there without any authority of law, and people suffering thousands of crores of losses in their working because of the ban that was imposed all this while and now which has been held to be without authority of law, then I am sure the government will be also held responsible for paying to the common man there for his suffering, both in terms of money and otherwise, that the suffering has taken place to business in Jammu and Kashmir. So every person who was dependent upon the internet facility for doing his business, and because of the suspension could not do business for all this while, like Mr. Andrabi mentioned about the tourism being hit very badly. So I'm sure the government will definitely be made accountable for paying to all of them, and securing the losses that they have suffered, and ensuring that in future, if ever they were to do something like this, then this kind of a consequence will also entail. Because if you have a rule and if there is a procedure established by law to stop internet, and there are several checks which are provided in that procedure, and without following that procedure, if you have just banned internet using your executive power, and court having held that it is not justified, then I don't see why the government should not be made responsible for making up all the loss that has been caused to people in the state.
Some important thoughts there. Of course, we must temper this by pointing out that in some cases there may be a justification for shutting down the internet. Yes, Tehseen, you wanted to come in.
See, it's not just about commerce. Vikas Singh, I completely agree with him. Commerce is very, very important, but it's also about your right to life. You see, today your entire Ayushman Bharat scheme, your entire insurance scheme is on the internet. Your entire medical report is online. So how do you access all of that? How do you get your treatments done? How do you get other facilities done which are critical to your life and welfare without the internet? So I agree with the idea of a balance, but the balance with, if you feel that there is a problem, I can understand social media sites for a couple of hours are put on hold, or WhatsApp is put on hold for a couple of hours, but at least essential sites should be allowed to function. There has to be some mechanism that comes out. You cannot have a blanket ban on anything indefinitely. That is not how democracies work. It cannot simply function this way. There must be accountability, there must be answerability, and there must be an aspect of fear and compensation to the government. Ultimately, we the people, they are answerable to. We are not answerable to them, they are answerable to us.
Absolutely, absolutely. Let's hope there is some forward movement after the Supreme Court order, and once again, very important point underlined by the top court, that access to internet is a fundamental right, and that's a key takeaway coming through. Thank you so much, Vikas Singh as well as Tehseen Poonawalla, for joining us today.